Episode 23 of the Bournemouth Lawyers Court Report Show takes a look at a high-range drink driving offence with a blood alcohol reading of 0.192, which we appeared on at the Beenleigh Magistrates Court in Brisbane.
Yeah. Honestly, I think that 24/7 an understatement to my day-to-day. If ain't no way, then I'ma make a way. They say it ain't no way. I ain't never listened, kept them at the distance. This is for the ones who ain't afraid. And this is more than some paper chase. I wonder who else can say the same.
G'day, it's Josh Borman from Bournemouth Lawyers. I'm just sitting out here at the front of Beenleigh Magistrates Court in Queensland, where I appeared on a high-range drink driving offence where my client had been charged with a blood alcohol reading of 0.192. So the reading was obviously very high, well within the high range, above the high range threshold, and that was obviously seen as an aggravating feature in relation to the overall seriousness of the offence. But we handled this case quite well, and so did my client. The one very strong thing working in my client's favour was the fact that he had an exceptional traffic record. He's been driving since 1981, and he's only had one minor indiscretion in that time, which was a speeding offence in 2010. So it was a very strong record, which showed that in the past my client had conducted himself with a high degree and high level of safety and responsibility on the roads. It also showed that this particular offence before the court today of high-range drink driving was very much out of my client's usual character and how he would usually conduct himself. So we frame this particular offence as a one-off isolated type of offence where our client has had a brain snap and made a very, very poor decision on the night of the offence. We got our client along to do a traffic offenders program. He excelled in this course. He had a very good and well written workbook, a completion certificate. We also helped our client get together some very strong character references. He got a work reference which indicated that he needs to be able to be mobile 50% of the time that he is at work, and that being off the road has significantly affected his job, and it has caused his employer to demote him, and depending on the outcome of today would also depend on the future of his employment with that company. We also got a letter of support from his wife, which just indicated how he's usually a very responsible adult, a person who his kids look up to, and also that he is the main income earner for the family. And certainly they hold grave concerns about his ability to be able to provide for the family whilst he's off the road. And we also helped our client put together a strong letter of apology from him to the court, just outlining exactly what went wrong on the night of the offence, what he's learnt, his grave concerns, and his overall attitude about the offence and moving forward. So we got these references, the traffic offender program and certificate. We also got some medical reports surrounding his medical condition, tendered that before the magistrate, and the magistrate was very receptive to all of that material, and also our oral submissions that we presented on behalf of our client. The obvious big elephant in the room for this matter was the fact that the blood alcohol reading was 0.192. It was very high. He should have been nowhere near a motor vehicle, and for that reason we had to address that level of offending in relation to how high the reading was, but also try and downplay it a little bit and mitigate his situation by discussing other objective features of seriousness surrounding the incident. The fact that he was the sole occupant of the vehicle, he had about 300-400 metres to drive home. There was minimal traffic on the road, and he was pulled over for a random breath test. All did mitigate somewhat the situation my client was in. And of course we discussed all the personal and subjective features in relation to my client, his need to be able to drive for work, his good character, his very good past traffic record, and his need to be able to provide for his family as a family man. So this was all well received and taken into account by the magistrate. He decided to convict our client and disqualify him for a period of 8 months, and fine him an amount of $1,500. Keeping in mind that for all high-range drink driving offences, the absolute minimum period in Queensland that a court can hand down is 6 months. And given how high the reading was at 0.192, our client got 8 months. He was very happy with that. He was probably expecting more around the 12-month mark, but with 8 months, it gives him a bit of light at the end of the tunnel to be able to move forward with his job and have a plan in place to get back on the road in the near future and be a responsible person and continue to provide for his family. So if you found yourself in the unfortunate position where you've been charged with a traffic offence, drink drive, drug drive, suspended, disqualified drive, any serious or major traffic offence in Queensland, and rest assured that we specialise in this area of law, and I'm happy to have a free first initial telephone consult with you. If you want to give me a call, it's sorry, 1300 941 900. Or alternatively, go along to our website, which is bormanlawyers.com.au. That's BOORMAN lawyers.com.au. What we've done there is we've provided quite a large information hub online for people to go along and read up about offences, penalties, statistics. There's videos, there's blog posts, there's articles, issues surrounding laws, which may be relevant to the particular situation that you might find yourself in. You can read up on that, familiarise yourself with what's going on in relation to your situation, and feel free, again, if you want to give me a call to discuss your matter further and see what we can do for you. Our number is 1300 941 900. So thanks for tuning in today, guys.